Welcome to our webinar today. Thank you so much for joining us. We're really excited to have two of our favorite attorneys on the line today to answer your questions and really go over some of the things that are changing in California. It's a totally different world than it was last year, and even from the last time that we had our attorneys on here, a lot has changed, specifically the COVID Tenant Relief Act, which directly impacts almost every single landlord in California. So for those of you guys who don't know the speakers yet, Brad Barth is with us at the top there. He is from Barth, Calderon, LLP. He's a partner at that firm. He specializes in estate planning and asset protection. He'll be talking about how this act will influence your asset protection strategy. And we also have Stephen Williams from Freed & Williams, and he's a partner at that law firm as well. They specialize in evictions, and so they'll both be able to give you some really great insight and help you plan out 2021 as well. But before we get started, I just want to mention that we are going to have a great Q&A session. So really think about the questions that you have. This is a great opportunity to get them answered by experts. We're also going to be sending you the recording tomorrow, so if you can't stick around the whole time, you will be able to see the recording. I believe this will be roughly an hour, may go over depending on how many questions you all have and Brad's and Steve's time. I will also share Brad and Steve's information so that you can follow up with any additional questions that may not get answered during this webinar. So with that being said, I'll pass it over to Brad and Steve. Thank you guys so much for coming on again to give us a great update. And I'll have you guys take it away.
Great, thank you. All right, Steve, we'll let you start.
Thank you. So, yeah, I'll go ahead and get started. I was just telling Alexandra I have about 15 slides. I'm going to go through them pretty quickly so that Brad can also chime in with some updates and some strategies, and then we'll reserve some time at the end for some specific questions. I did already get a few of you who emailed some questions, so I'll try and hit those as I go along here. So let's get started with this this new legislation. It's referred to as the COVID Tenant Relief Act. I oftentimes, since I practice in local jurisdictions where there's very strict rent and eviction controls, I kind of just call this, the state law moratorium. So I may refer to it as state law or CTRA throughout this talk, but you'll know what I'm talking about. So this is some legislation that was passed to protect tenants from evictions, and it was effective September 1st. And it specifically protects tenants who don't pay rent and are affected by COVID-19 somehow financially. So let's go ahead and get started here. So there's two main. We're going to first focus on the non-payment of rent aspect of protections of the CTRA, and there's two main periods that are applicable under this new act. There's the protected period. So this is for tenants that did not pay rent between March 1st and August 31st. And in that situation, it requires that a tenant provide a declaration showing financial inability to pay rent due to COVID-19. And so long as they do that, they're generally, during this protected period, protected from any eviction forever for non-payment of rent. Again, that applies March 1st to August 31st. And I'll get into more details with this and how a notice is given and what should be included in that notice shortly. But so the first period, the protected period, March 1st to August 31st. There was a prerequisite that was required in order to avail yourself of the right to potentially evict someone during this period. And that was a mandatory informational notice that was supposed to have been given to the tenants by September 30th. If it was not given and the tenant was not impacted by COVID-19, you're going to be out of luck. The tenant you will not be able to evict the tenant for non-payment of rent during that protected period of time. Now, if you did give that notice, that mandatory notice, then the tenant is required to provide you with a declaration. Again, I'll get into some of those details in a bit. Provide you with a declaration of financial impact due to COVID. And if they do that, then again, you can't evict them during that period of time. So I suspect that most tenants who didn't pay during that time would probably qualify and be able to sign that declaration, return that declaration, preventing you from evicting. So if you did not give that notice, you're probably no worse off than most landlords, even the ones that did, because the tenant would probably be protected anyways. That's at least been my experience. Now there's the transition period. So we talked about the non-payment of rent from March to through August. Now the transition period is September 1st through January 31st. So that is, there's protections that are afforded to tenants that don't pay rent during that transitional period as well, but there's an additional obligation of the tenant. So again, it requires the tenant to provide a declaration showing financial impact due to COVID. And then by no later than January 31st, the tenant must pay at least 25% of the rent due during that time period, September 1st to January 31st. And if they do, then they're protected from any eviction for non-payment of rent during that transitional period. Now, there's no mandatory informational notice required for this transitional period. So, in short, the tenant gets the protections if they, 1, return a declaration, and 2, pay at least 25% of the rent, not during the month within which it's due, but by January 31st. So if they didn't pay September rent, they return this declaration, and then they pay at least 25% of the rent by January 31st, you can never evict that tenant for that remaining 75%. Now I'll talk about how you can recover that rent as well as rent during the protected period in a few minutes. But so those are the two applicable periods for non-payment of rent under the CTRA. Now, throw away your old 3-day notices to pay rent or quit that everyone is so familiar with. For any non-payment of rent through both the protected period and the transitional period, a 15-day notice is required. So this will replace your general 3-day notice, and it does not apply, of course, to rents before March 1st or rents after January 31st. This is just during that period of time. You're stuck with giving a 15-day notice to pay rent or quit. All right, and again, I'm going to get into some more details about that. I'm just sort of outlining what the laws are right now. I'm trying to do it somewhat quickly because I know we have a lot of questions that I'm seeing pop up. So hopefully we'll get to those. Hold on one moment. So, okay. So it provides protections for non-payment of rent. However, it also provides protections for all other evictions. So what happened is in January of this year, and I gave a talk a few months ago talking about the new statewide rent and eviction control laws. Well, what the CTRA does is it expands the protections of the statewide rent and eviction control laws, actually just the eviction control, to basically all tenants and all units now. So if you had a unit that was exempt under the statewide rent and eviction control, well, for purposes of eviction, you're now subject to the just cause requirements of the statewide law. And you may have been already. You very well may have been already, but if you were exempt somehow, well, during this period of time, and this runs through February, you cannot evict unless you have just cause under the statewide eviction control laws. And so general statewide eviction controls allow evictions for, a breach of the lease and nuisance. I did get a question. Someone asked, well, can I do an owner move and eviction? And that is a just cause under the statewide eviction control laws. So presumably, yes, you could right now. The optics of it might not be so great doing it during this COVID period, but technically you likely can. So again, non-payment of rent protections through January, eviction, any type of eviction protection through February. It doesn't mean you cannot evict. You just have to comply with the just cause requirements under the statewide eviction control laws. Now, Just in summary here, for non-payment of rent, the CTRA eviction moratorium applies only to rents between March and January. You have that protected period and then the transition period, 2 sets of rules. And then really the only difference is between for the transition period, the tenant has to pay 25% of the rent by January 31st. Pre and post-COVID periods, not impacted. Now, let's get into the 15-day notices. So these are, again, used for that period of time, March through January. And when counting the 15 days, you don't just count the straight 15 calendar days. You must not include, excuse me, Saturdays or Sundays or holidays. So that notice could very well run 20, 21 days. If you're around the holidays, even longer. So keep that in mind. So it's more like a 3-week notice. The notice must state when the rent became due, of course. The tenant's rights under the CTRA. So there's certain disclosure language that needs to be included in that notice advising the tenants of their rights under the CTRA. And guess what? The laws have actually codified and included a declaration, the specific language of the form that the tenant needs to sign in order to avail him or herself of the non-payment of rent protections. So that declaration, that handy declaration, will go right with your 15-day notice, and the tenant simply has to sign it. Doesn't have to do much brain work or guesswork there. They just simply sign it and return it, and they get the protections under the CTRA. Now, again, if it's the transitional period, then they have to pay 25% of the rent by January 31st, but otherwise they get the protections. So again, that declaration, in order to be covered, they must return that declaration, which again will accompany your notice. And I'm going to give you just a little synopsis here. What's included? What qualifies? It's not all of these. It's any one of these. Then the tenant can likely sign that declaration and be truthful if they have any of these impacts here and return that to you. So loss of income, increased expenses, and here's the catch-all: other circumstances related to pandemic that decreased income or increased expenses. What does that mean? Did I have to go to Costco and get additional things that I wouldn't have otherwise had to get? Maybe, I don't know. But they've made it very easy for a tenant to sign this declaration and return it and get these protections, which again preclude you from ever evicting the tenant for non-payment of rent during that period from March through January. All right. So even when February rolls around, you think, aha, well, they didn't, they returned the declaration and maybe they paid 25%. Well, I'm past January 31st, so now I can evict them for not paying during that period of time. You can't. You can never evict them for that. All right. So here's a little caveat. So in addition to that declaration, high-income residents have to actually provide proof of the impact, the adverse impact of COVID. So for non-high-income residents, just simply return the declaration is sufficient to get that protection. High-income residents have this additional hurdle of providing you with proof of inability to pay or some impact. However, you must have proof of high income before you serve that 15-day notice, and you cannot go fishing for it. So really, how do you get that information? Likely in your tenant rental application is where you would have it. You don't have it there, you can't hire an investigator, can't go searching around, you can't ask. In those circumstances, you may see the person driving around in a Tesla and some high-powered job. Unless you have actual verifiable information that the person is high income, you can't require the tenant to provide that additional proof by claiming that the tenant is high income. And what is high income? Well, it's defined as 130% of the median annual household income, or $100,000, whichever is greater. So what is the median household income in your area? It would be 130% that or $100,000, whichever is greater. I know I practice in San Francisco, and 130% is right around, it's right around $130,000. So it's like $129,000. So this 100,000, anyone who makes over $100,000 in San Francisco would qualify, and anywhere really. So a little bit more on this. So the non-high income tenants, you cannot evict unless the tenant fails to return that declaration or fails to pay that 25% by January 31st. In those circumstances, you could conceivably actually evict the tenant. High income residents, you cannot evict unless the tenant fails to return the declaration, fails to provide documentation of inability to pay, and fails to pay 25% of the rent due for that period of time by January 31st. All right, I'm going a little quickly here, but again, hopefully we'll have plenty of time for some questions. So if the tenant fails to return the declaration, like I mentioned, or fails to pay that 25% if it's due, then you can file an eviction action. You could do that, after the 15-day notice expires. However, here's a bit of caution. It's not over at that point. That tenant can still come running into court, waving around that declaration after you filed your eviction action, and ask the judge for what's called relief from the action. I actually call it like in law, when an attorney's made a mistake, they can go into court and have some decision set aside based on a mistake. I call it an oops motion. Oops, judge, I made this mistake. Well, the tenant can run in, oops, I forgot to turn this in, my dog ate it, whatever excuse they could have. And guess what? They can defeat the eviction and be precluded from being evicted if they wave that around and the judge agrees to accept it, which I expect the judges probably will. Judges are very lenient on attorney oops motions, so I assume they would probably be so on a tenant oops motion with that declaration. So you're not out of the, you're not in the clear simply because the tenant doesn't return that declaration and within the time period, and you file your eviction action, you still could end up, having to kick that case right out of court. All right, so the eviction protections. So again, we've sort of covered this. I'm just hammering it home. For rent due between March 1st and August 31st, tenant can never be evicted, but you can go to small claims court if they provided the declaration. For payments during that transitional period, if the tenant pays that 25% and provides the declaration, then they can never be evicted. And that additional 75%, you can recover that in small claims court. So for the protected period, 100% of that rent can be collected in a small claims court action. For the transitional period, 75% can be collected in that small claims court action. And so finally, again, so small claims, people say, well, what if the rent is over, $20,000 that's due? It's accumulated over these months. Well, the CTRA opens up small claims to it's unlimited now. Any amount of any dollar amount can be subject to a small claims court action, so long as it is rent. So you can't say, hey, $20,000 in rent, and he damaged my garage, so I'm going to throw that in. Can't do that. In order to avail yourself of the unlimited scope now of the small claims, it all has to be rent. So the rules, the limitations are relaxed in small claims to allow you to bring a rent claim, no matter the amount. And that's important because you don't have to get your attorney involved and file a superior court case and pay the high filing fees and wait the very lengthy time it takes to process a superior court case. Instead, you can file your case in small claims court, and presumably it will be remedied much quicker, although that remains to be seen how the courts are going to handle a flood of these small claims court actions. So what's important to note is you cannot begin that small claims court action until after or till March 1st or later. So even though the rent was due sometime March through January, you still have to sit on your hands and wait until March 1st of 2021 in order to file your small claims court action. So with that, again, I'm sorry I went a little quick. I'm trying to get through this, but I believe that's it. Yes, so I will, unless Alexander, you want me to go back to any particular slide, I'll stop sharing this. If there's any slide, let me know. Otherwise, I'll stop sharing.
Yeah, thank you so much for that, Steve. That was perfect in terms of just like being very concise on the rules. I think before we move on to the questions, because I know I saw a lot of them, I would like to have Brad go over a little bit more about what this might mean for your area of expertise, Brad, which is, asset protection. So obviously landlord risk is now higher, losses maybe coming their way. What are you seeing from your perspective?
Yeah, so as Steve, by the way, nice to see you again, Steve, and thank you everyone for your time and attention this morning. So as you were giving your analysis, Steve, I kept on saying to myself, I mean, I always represent landlords. I'm always with the property owner. So I see this as from a different perspective, right? With my rose-colored glasses, I always look at it. You have all these protections that are built in for tenants. That's great, but where are the protections for the landlords? Because I always say there's a trickle up effect to this, and I'm on the phone all day long with my clients who are worried about not able to evict. They can't get any money out, but their mortgage holder, their lien holder is on their case. So we're looking to protect assets. We're referring a lot of clients out to bankruptcy counsel. So Steve, what I would like to know, just from your commentary, from what you're hearing out there, it's all great that we have all these protections for tenants, but what about the property owners themselves? What's the relief for them? That's my first question.
Yes, so, and I represent property owners and landlords, and I tell my clients all the time, and this was even pre-COVID, that all the laws that are proposed are tenant friendly. So very rarely do we get something that's proposed that benefits the landlord in the landlord-tenant situation. And there's a major one, Proposition 21, that was defeated. So landlords, victories are the defeats, not new laws, unfortunately. I'm just not seeing a lot of laws that come out to protect landlords. Now, that being said, like in San Francisco, there was a law that is proposed, and it will probably pass, that is providing money up to 50% of the rent to landlords, and smaller landlords. I believe it's 10 units or less, if I recall correctly. That they will pay up to 50% of the unpaid rent to landlords. So if the tenant doesn't pay the rent, now the landlord has to forgive the tenant the rent, so you can never, seek that in a small claims or other type of action. But at least afford some relief for the landlord. And there may be other local jurisdictions that are doing things like that. I'm aware of San Francisco. I'm not aware of other areas. But there may be some other jurisdictions that are doing that. And then, of course, you have some state laws like the PPP loans, things like that. Some businesses may have been able to avail themselves of that sort of funding, or certain types of business loans or things like that that may be relaxed right now to help small property or business owners.
Right. Great, thanks, Steve. So and that's the challenge that we have, and I do also made a note about the PPP and some of its limitations on what it can be used for. But so that's so Alexandra. So my perspective on this is I call it normally it's trickle down. This is more of a trickle up concern, because it's ultimately when my clients, and Steve, your clients as well, when they acquire these properties, I mean, they have personal guarantees on the line as part of their overall investment as far as purchasing these properties. Sometimes there may be one property that's carrying another property that was all pre-COVID. And so what we're concerned about is now the asset protection to the clients, because if the properties themselves, they typically have recourse options that are built inside there. And so we're now worried about how does the bank then go above and beyond the client themselves, the property themselves, and go after the client's individual assets. And so now we're looking at structures, your typical structures. You got LLCs for property holdings, not only for the liabilities arising up from the tenants themselves for the activities on the property, but now we actually want to protect the client's assets above and beyond just the properties themselves. Now we're looking at protecting clients' retirement plans. We're looking at life insurance cash values. We're looking at other cash instruments and brokerage accounts, personal residences, second residences. So that's kind of what we've been seeing a lot. And it's beyond just pure residential. It also deals with our commercial landlords. But I think also it's an important thing, since we spoke last time, two major things have happened. I just want to kind of share some of this since we're sharing updated current events. And one of them has to do in my space in the estate planning arena is the passing of Prop 19. And I think we remember last time we were on the call here, I tried to explain to everybody that there's an idea called rat poison, right? Where you put a little bit of good food along with a lot of poison, right? And so there was a little bit of good inside Prop 19, but the consequence from an estate planning perspective actually was terrible. I think it was back in 1978, I believe, when Prop 13 was first passed. There was some excellent property tax exclusions in the estate arena, specifically with what's called the parent-child exclusion. And this is found in a Revenue Taxation Code section 63.1A, 1 and 2. And that had to deal with primary residences and then for all other non-residential property. So the nice thing is, at least on what used to be the Prop 13 for residential from an estate planning perspective, was that when you had a child who inherited or was otherwise transferred a property by death or by gift, a property, they took the transferee, the child took the parent's property tax basis, and there really wasn't any limitation on that. Whatever it was, that's what they got. So from an estate planning point of view, you have some parents who purchased a property 35 years ago for a value of $35,000. Now that same property is worth $1.5 million, just with the natural appreciation of property values. But mom is still paying property tax based upon that $35,000 mark, which is great. And so long as it was mom's primary residence and the children inherited, that parent-child kicked in, and consequently the kids would inherit it without limitation on its use, and they would enjoy that original $35,000, of course, adjusted for inflation, tax basis. That's gone now. What they did is that there has to be a declaration under penalty of perjury that the kids themselves are now going to occupy that residence as their own primary residence, which nobody ever does. I mean, there are a very small majority of people who may occupy the parents' house as their primary residence, but the substantial majority of people either want to rent it out, or have some other form, maybe keep it as a legacy or vacation home. But so that's gone. But I think more importantly, it has to do with all other non-primary residence properties. And we used to have what was called a $1 million exclusion from Prop 13 based upon the assessed value. And if the property was owned by a husband and wife, they got to double that up. It was a $2 million exclusion from Prop 13 reassessments. So now, in other words, you used to have a residence, and you could have a very low basis, and then it appreciated substantially over time. The kids would get that property, no problem, without question of reassessment. But then they also had a property, a commercial building, for example, or a rental property or an apartment building, and they would get a $1 or $2 million exclusion from Prop 13 reassessment. It's not a lot, but it's better than nothing, right? So you used to get $1 or $2 million of relief from reassessment. That's totally gone. So that $1 million exclusion is completely gone. And that's why I keep on saying that there was a little bit of good as far as being able to transfer your current tax basis for 55 plus, not just in your own county, but pretty much anywhere in the state. There was good. There was relief for firefighters. That's good. But consequently, you also lost a lot of bad. And I don't know if that was necessarily highlighted, because it adversely affects what we do from a succession perspective. We have a lot of clients who do gifting to kids to minimize their estate taxes. You do what's called qualified personal residence trusts, which are delayed gifts over a period of time, 5, 10, 15, or 20 years, we were all under the assumption that that property would not be reassessed, but now it could be reassessed while mom and dad are still alive, because it transferred, and then the child themselves are no longer occupying that property as their property because mom and dad are still alive and they're occupying it. So it causes all kinds of problems. So I think that's one very important concept I wanted to bring, that this Prop 19 really kind of muddy the waters, and I think the dust has yet to be settled as to what to do. Now, it becomes effective, I believe, of February 18. I think that's the date. I think that's the date that it becomes effective. So a lot of our clients are trying to figure out, what do I do now to preserve my exemption? I do have that very low tax basis. I want to be able to transition it. And so we're doing a lot of gifting. So it kind of cuts both ways. You're gifting, one, to preserve the unlimited parent-child exclusion from Prop 13 for primary residences. You're gifting to maximize or preserve whatever's available left of the $2 million all other non-primary residence properties before February 18. At the same time, because the other political issue we're dealing with, as far as the presidencies and Congress, we're also worried about a loss of a substantial estate tax exclusion, which happens to affect a lot of my clients also. Currently, we're enjoying an $11.58 million exclusion from estate taxes. And if you're married, you can double it up. That gives you about $23 million. But here again, that may be, thankfully, there was at least a split in Congress. So you have a Democratic president and a Republican Congress. So what we were worried about was what do you call it, the blue wave, where you had a Republican president and a Democratic president and a Democratic Congress. We were worried about a large sweeping tax changes taking place effective in 2021, which under the Biden tax platform would have brought us from $11.5 million per person down to $3.5 million from exclusion. And what that basically means, for those of you who aren't familiar with it, it's the amount of net estate that you can transfer to a beneficiary before you, that is the estate, incurs an estate tax. Presently, it's 11.5 million. Everything above that is subject to a 40% estate tax. If you're married, you can double it up, hence 23 million. What we were worried about in the Biden administration is it being lowered down to 3.5 million, and then the percentage being increased not to 40, but to 45%. So they lower the threshold and they increase the amount of tax base. So we were worried, and a lot of clients are trying to maximize now, planning, not only because of the Prop 13 issues as a result of this Prop 19, but also trying to preserve and maximize this 11.5 exclusion before it went away. But now that we have a split in the Congress, we're now looking at not a 3/4 loss of the exemption, but maybe a 50% loss of the exemption, which is already set to occur per law on January 1st, 2026. I'm giving you these numbers because the planning that we need to do is the same regardless, and our window of time to moving property under the new California Prop 13 is very limited. The idea being is that if we're going to lose exemptions, what can I do now to start moving assets out without, quote unquote, disinheriting myself? So we do things and not in spite of ourselves, but you also may want to transition to your kids to maximize some of the the original Prop 13 parent-child exclusions. So you're kind of getting a two bites at it. You're transferring to preserve the California property tax preservation before it goes away, and you're trying to maximize the federal estate exemption before it goes away as well. And so even if there is not a sweeping change in Congress as a result of a Biden administration, the present law is that January 1st of 2026, we are going to get a 50% haircut. So the tools that we're using now are the same tools. Why do I think it's relevant now? Because whenever we're moving, especially for this particular audience, whenever we're moving property, we have to get basically an appraisal. Whenever you're gifting, and regardless of the mechanism that we use for gifting, whether it's straight gifting trusts, CUPERTs, slats, or other forms of funny sounding acronyms, we have to have a fair market value of the property in question. And as you can imagine, with only 45 days or so left in the year, and everybody trying to do a lot of year-end planning to maximize the preservations that they still have, appraisers are just crazy busy. And if you have these properties owned by several individuals and they're held in corporations or LLCs, not only do we have to have the properties themselves appraised, now you have to have a business valuation possibly for the discounts for marketability and control issues. So it causes a level of complication, and people need to move now on this because everybody in the industry, myself, Steve, the entire appraisal world is just jam-packed with year-end planning. So I just want to make sure that since we are talking about current events, Steve, you brought us up to date on the tenants liability. I'm sorry, the tenant issues, but I wouldn't be able to walk off of this presentation, Alexandra, unless I at least addressed what the consequences were of Prop 19 and the consequences of a Biden administration, coupled with a Republican Congress. So I want to make sure I kind of got that out there.
Yeah, absolutely. I think that's completely relevant. And honestly, I think that, this window of opportunity that's left is so short. We really need to move on this quickly. So, so we do have a lot of questions that have come in. And some related to your area, Brad, some to Steve. So I'm going to just start kind of from the top here. We're going to go back a little bit into what Steve was talking about. Actually, Steve, I'm not sure you reiterated this, but this was a good question. They're asking about the rent increase that was put into place through AB 1482, and wondering just if you could review if that is still in effect and what it was about back in January.
Yeah, so the rent increase limit, so just in short, so I referenced briefly the AB 1482, which is the statewide rent and eviction control laws. And so there's two components, rent control and eviction control. My talk focused on the eviction control aspect. The rent control aspect is that for most properties, and there are some exceptions, but for most properties, rents can only be increased annually in an amount no greater than 5% plus CPI. Now, in my area, that was, I think it came out to 9%. I believe CPI was 4% the last time I checked, which means the total potential rent increase was 9%. Now that may vary from area to area, but those are still in effect. So, if you've given your annual increase this year, you have to wait till next year. And one thing that probably a lot of you may know in rent control jurisdictions is that a lot of times they afford a landlord an opportunity to what's called bank a rent increase. So let's say you didn't give it in 2020, your 5 plus 4 CPI percent increase, then you can put it in your pocket and give it with the next year's increase. That's under most local rent control jurisdictions. The state law does not allow for that. So if you have not given it, you may forever lose it. I know times are tough right now, and there may be reasons not to give it now. But yes, so those limitations are in effect, and again, it's 5% plus CPI.
So another question that I saw come up a couple times had to do with that notice that you were talking about that should have been provided by September 30th, I believe. So in the case that it was not provided, can you reiterate what happens and what the difference is?
Okay, so let's first assume it was given. Okay, let's say it was given before the deadline. And you've got a tenant who hasn't paid rent during that protected period. Let's just say they didn't pay, August rent. If they did give it, if the landlord did give that, then you give your 15-day notice. And if the tenant does not return the declaration, you can proceed with an eviction action. But again, the tenant may come into court and wave it around. But conceivably, you could proceed with a non-payment of rent for August rent if you've given that informational notice, you've given your 15-day notice, and the tenant did not return the declaration. If you did not give that form, that informational form by the deadline, then you cannot give your 15-day notice. So you can never try to evict the tenant for that rent between March and August. So you're gonna have to wait until March and go after that tenant for, non-payment of rent in a small claims court action for just the rent, not possession. That's my interpretation of having, if you miss that deadline.
Okay. So then that means that for a tenant that's moving in this month, you don't need to provide the notice. It's not going to do you really any good, right? Okay. And then the other thing as well was here, if, and then also I just want to, Joey was asking, and I think you answered it as well. The tenant can provide that declaration at any point up to the day of the trial, right? It doesn't have to be provided by a certain date to be valid.
Yeah, well, technically the law says it has to be provided within that 15-day period of the notice period. However, there is that sort of oops. So to answer your question, yes, the tenant can bring it into court. Look, I signed it, Your Honor. Here it is. It's signed. Again, my dog ate it. It was inadvertently thrown away. Whatever the excuse is. And my guess is the judge would probably be inclined to forgive the tenant for not complying with that 15-day period and prohibit the landlord from evicting the tenant.
Another good question too here from Cheryl, saying that the renter has essentially broken the lease in multiple different ways other than non-payment of rent. So they haven't gotten the renter's insurance, they've sublet without permission. Is there a way for them to maybe evict the tenant for those reasons, and how would that look like? Oh, I think you're muted, Steve.
A caveat here, check your local rent and eviction controls, because now that particular scenario in San Francisco, Oakland, Berkeley, where I practice, no, you're not going to be able to evict the tenant for any of those things. Now, if you're outside of those areas, and you're, again, remember, you're subject to the state law eviction controls. Most units are going to be subject to those state law just cause requirements. And so to answer your question, yes, breach of the lease, subletting without authorization are grounds for eviction. They're just cause grounds under the state law. So yes, you can still proceed. I'd be a little cautious about doing so for something like not providing renter's insurance, but technically you may be able to. So how that would look is you'd first have to give a notice to cease, like a warning notice. Hey, you need to comply with this. If the tenant does not comply, then you can serve a formal type of a perform or quit type eviction notice. So yeah, presumably you still could if you're not subject to a local law that is greater than what the state laws allow.
And can you start an eviction right now for any tenants that didn't pay rent in January and February of this year?
That's a good question. So in short, yes. Now, whether you're, so sort of an aspect we didn't really talk about is the courts have prepared specific forms for unlawful detainer, which are eviction actions when you file them in court. So there's all different kinds of information you have to provide under penalty of perjury. And I haven't looked at one of those forms recently. There's got to be a box to check that this is rent not during this period. So conceivably, yes, you probably just have to make sure you navigate your particular, county court to make sure you get the right form so they don't think you're bringing in an eviction action for rent during this, prohibited period. So yes, you can. Now the courts are open for evictions where they were closed for a significant amount of time. They are open.
Great. And then for going back to rent increases, so you can increase rent right now in any county if you comply?
Not in any county, no. Again, check your local laws. I've got restrictions. They go by city, by county. So in short, check the local area. Yeah.
Okay, great. A couple people asking about the slides, Steve. Do you share your slides or will we be just getting the recording?
Yeah, I'm always happy to shoot them over to you, Alexandra. Just remind me and I'll have them sent over to you.
Okay, perfect. May asking the maximum in small claims. I know you said there is no max now because of the new law. Is that indefinite or is there an end to that at some point?
You know, I think it's so long as it is for rent during this protected period time. So March through January 31st, then it's indefinite, subject to the statute of limitations. You can only sue for breach of contract up to 4 years if it's written. So if you have a written rental agreement, 4 years, and then 2 years if it's an oral contract, an oral rental agreement. So you want to get your claim in within that statutory period of time, but yes, you can, so long as it's for that protected period, so March through January. After that, I do not believe they're going to keep the doors open for February, March, April rents of 2021. I don't think they're going to do that. That may overburden the small claims court system. So as far as I know, it's just for the period of time that the tenants don't have to, that you can't evict the tenant for paying rent, for not paying rent.
Got it. And if you're renting out rooms in your private residence, your personal residence, then do these laws apply to you too?
So definitely the so non-payment, yes. You definitely have to comply with the state laws. There's no exception for that scenario.
Okay. So now I see that we have a few more that are sort of already covered by you, Steve, and I want to move on to Brad a little bit here, because I see some questions coming in as well about some of the propositions that came through.
Right.
So let me see here. I want to pull up one that I saw earlier.
I also saw a couple of good Q&As I want to just go ahead and address.
Yeah, you saw some. They might be the same ones that I saw. You guys are putting in so many questions. I'm losing.
Right. No, it's great. And then so one of the things that they were talking about is the preservation of the parent-child when the property is held in an LLC, which is the way that most people hold properties. And certainly if you're one of my clients, I would advise you hold your properties in an LLC. The difficulty is that the parent-child exemption, the exclusion from Prop 13 was a parent-to-child exclusion, not an LLC to child. So when you took your property and you put it inside an LLC, it was kind of a trade-off. Yes, you got the limited liability of the LLC. Yes, you got the asset protection if set up correctly, but at a cost of giving up or forfeiting your parent-child. So there is a proper way to do this, and that you don't wind up forfeiting it, where you can preserve the parent-child and yet still be afforded the protections of limited liability and asset protection, but it's not a direct transfer into an LLC. So that's one of the issues, and I don't know now how that's going to make much of a difference, because one of the big selling points of that other model than a direct LLC transfer was a preservation of the Prop 13 parent-child exclusion. Well, now that may go away. So I don't know if that's going to be a main selling point. I think the recurring benefit would be not triggering due on sale clauses with lenders. That's a big deal, and some other preservation issues like privacy, et cetera, that's still relevant in this model B as opposed to direct transfers inside. That was one question. I thought that comes up a lot, and it's worth addressing. Another question came up regarding inherited properties with step up and basis. Now, that's not only has step up and basis been on the chopping block for many, many, many years. It never quite got the necessary votes to completely eliminate it, but it is one of the Biden tax platforms again to completely eliminate step up and basis. So just for the benefit of the audience, let me go ahead and tell you what a step up and basis is and why living in California is awesome when it comes to having a step up in basis, because we don't get one step up, we get a double step up in basis. So the worry is like this. So you buy a piece of property for $100,000 and that property naturally appreciates, let's say $1.1 million. Well, your basis was 100,000 and you sell it for 1.1 million. That means you have at least $1 million of gain. When you tack in California, you tack in federal, and you tack in a little Obamacare inside there, you're going to be paying about 35% capital gain tax here in California, which you're going to be cutting a check for $350,000 to various governmental agencies for the privilege of selling your property. So what we normally would tell our clients is, listen, don't give your property away during lifetime, die owning it. I know it sounds a little weird, but it's great at estate planning. Die owning your property, because when you own the property and you pass away, the beneficiary typically would be the kids, would get a full step up in basis. And what that means is that now with that, in my example, if you bought the property for 100,000, but at time of death, it was worth 1.1, well, that basis got reset. It got reset to 1.1. Now the kids have a new adjusted basis, 1.1 million. It got stepped up. And then the kids sell the property, 1.1, basically date of death plus 1 day, 1.1 minus 1.1 equals 0 at 35% is zero tax. So we just saved our client $350,000 in taxes by dying with the property through their estate plan as opposed to inheriting it. I'm sorry, as opposed to being gifted. That's in general. The reason why California was good is because we got a double step up in basis in community property. So in other words, when one spouse dies, you got a married couple, one spouse passes away, the property got a full step up in basis again, not a 50% step up as in the other 37 common law states, but in the community property states, you get a full step up, which is great because a lot of surviving spouses may want to simplify, may want to downsize, and then they would go ahead and sell the property again and pay no capital gain tax. I just had a transaction happen here, Alexandra, just a couple of months ago, and the husband passed away of cancer unexpectedly. And if you want to make lemonade out of lemons, that she just saved $20 million in taxes as a result of this, of the sale of a business as a result of this. So it was a good thing. But also under the Biden platform, they're going to go back to historic norms, as I mentioned already, from 11.5 to 3.5, and also looking to eliminate completely the step up in tax basis. So I don't quite have the crystal ball on that one, but that's something I would be paying particularly attention to, because not only a step up in basis good overall, but here in community property states, we get it twice. And so that could be a major loss to all of us as property owners who typically benefit from appreciating value of the assets. Another question that came up had to do with, can I please repeat what that 1/1/26 date is all about? And so basically the current law under the Tax Relief and Jobs Act that President Trump put into place as of 1/1/18, I believe it was, had a built-in sunset where we went from the Obama exemption at what was present, which was 5.5 million. He increased that exemption to 11.5 million. And again, that's the amount that you can transfer, amount of net estate that you can transfer before you get whacked with a 40% estate tax. He only got 10 years on that. Yeah, so there's a built-in sunset. So what is that sunset date? January 1st of 2026. So it must have been 1/1/16 if it's 10 years. That was the amount. So there's a built-in date of 1/1/26 where we're automatically going to get a 50% haircut. That's how the law is. And both sides of the aisle can sit back and say, we didn't do it. It just happens automatically. So as of January 1st of 2026, the estate exemption goes from 11.5 down to 5.5, and it's being indexed for inflation. So not to make it even more confusing, it actually should fall somewhere around 6 million. This is assuming that somewhere between now and then, there isn't a change in law. Like I said, under the Biden administration, we would have just skipped the 50% and gone down to 3/4 loss at 3.5 million, or the Congress could act in such a way that they actually make the Trump law permanent, which I find to be very unlikely because we have to pay for a pandemic, or they could just increase the amount, to some other arbitrary number. Just one of those things to pay attention to. And I guess just one last comment I saw, a very simple statement, Prop 13 dead, question mark. I think for all intents and purposes, the answer is yes, although it did pass back in 1978 with a 79.7% approval. That was just taken away from us. I'm sorry, I can't help it. I advocate for my clients, and I don't like it when the government basically uses one thing and steals from you on the back end. Sorry. Okay. Get out there.
I mean, it is quite incredible. I had no idea that it passed with such a high percentage before.
Everybody, well, that was back when originally, but like I said, everyone was just looking. They were selling it one way, and they had their hands in your pocketbook over here. It's very, very deceitful.
Okay, well, gosh, the questions keep coming in. So I'm going to turn it back to Steve real quick, because I saw actually several questions just about ultimately still asking about rent increases. A lot of people, what to do if you haven't raised rent in a really long time. And it sounds to me like you don't really have much of a choice. It's still the 5% plus the CPI. And I just want to reiterate that so that it's clear, because I saw so many people still asking about that. And it's really different based on every county and city, because every county and city has a different CPI. So correct me if I'm wrong, Steve, but is that in fact the bottom line?
Yeah, so again, now this is for units that are covered under state rent control. Not all units are covered. Now remember, there are some exceptions to the statewide rent control, like single family homes are exempt. So if you have a single family home, you're not subject to that 5% plus CPI limitation. And there's some other exceptions as well. But the main one, is if you own a single family home and you do not own it as a corporation or a real estate investment trust, then generally you're most likely exempt from the statewide rent control, which means you could raise the rent to prevailing market rents. Now, there were some limitations on even doing that as well. It's a little bit more complicated, but when a state of emergency is declared by the state or the government, then there's an automatic trigger on anti-price gouging. So, of course, when the COVID state of emergency was issued, when some of the fire emergencies declarations were issued, for a period of 30 days thereafter, you were limited with how much you could raise the rent. You could not raise it more than 10%. But my understanding is most of those statewide emergency orders have been lifted, or at least the period of 30 days after has expired. But there may be some local emergency that's been declared somewhere else. In my area, I think we're free and clear of those. But other than that, if you're subject to the statewide rent control laws, then yes, 5% plus CPI. If you're exempt from it and not covered under any local jurisdiction, then it is unlimited, so long as it's not in violation of some emergency declaration by the governor, which I don't think there are any right now.
Great. So I think some of the other ones that I'm seeing here is about, let's see here, giving a normal 60-day notice or just cause. So I saw like 3 or 4 questions about just cause. So let's say a tenant's lease is ending and they don't move out right now. What options does the landlord have? And under which conditions can a lease be terminated?
So this gets back to, okay, so I'm assuming you're not covered by any local law, but if you're not, then remember the statewide eviction control laws were expanded to cover most units in California now, if you're not already covered under some local law. So you have to have cause under the state law, and cause does not include a lease expiring. So simply because a lease ends, that is not in and of itself just cause to terminate that tenancy. What is just cause, like I mentioned, is something like I want to move in myself, an owner move in, or I want to move a family member in, or the tenant has breached the lease somehow, or is creating a nuisance, or is engaging in illegal activity. Those are all specific causes for eviction. under the statewide eviction control laws. And for now, those laws apply to many properties until the end of February, so until March 1st.
Okay, and another good question I hadn't thought about actually is, you mentioned the high income exception. What if that resident had a cosigner on the lease and the cosigner's income is well over 100,000?
Yeah, that's a good question. I have not analyzed that. My initial reaction is no, it goes to the tenant, not the guarantor. So if the tenant is not high income, then you cannot treat that tenancy as a high income tenancy. Again, without looking specifically at the law on that issue, my initial reaction is that you cannot rely on the guarantor in that situation.
So a question here about February 1st, because I think that was a date that you mentioned, Steve. Is someone asking here exactly what is happening on February 1st for landlords?
Well, then that's when we kind of default back into the normal non-payment of rent situations. You got your 3-day notice. They don't pay February.
Okay.
Remember, that's no longer subject to this, this period of March through January. So February 1st, things presumably go back to normal for non-payment of rent evictions. Now that's assuming nothing is extended. Who knows whether the January 31st deadline will be pushed back further, extended. But as of now, February 1st, you can issue your general 3-day notices for non-payment of rent and presumably proceed with an unlawful detainer eviction action if the tenant does not comply.
Okay, thanks for clarifying. And then also from Brenda and Rosalie, both asking the same question, if any of this applies to commercial leases, or if you know anything about what's happening in the commercial space.
I do. I guess that's a topic for another presentation. But no, everything I talked about today applies to residential.
Okay, good. And commercial, I think, is just its own world. And I know most of you on the call deal with residential. Maybe one of these days we can do something commercial for those of you who have commercial properties, although I know it's not most of you. Okay, and then a couple people asking again about the recording. Don't worry, you're going to be getting it soon. And then also, let's see if I can find any fresh questions here for you guys before I let you go. Let's see here. So a couple questions about, or actually just asking your opinion, if you believe that it's a good idea to lower the rent so that you can, stay competitive and fill vacancies. Is that something that you would recommend ever doing, considering the rent control laws that are in place?
That's a good question. And I've had a lot of clients do that. It's really a case-by-case basis. Some landlords, they're happy with their particular tenant. They want to keep them in there, so they want to make some concession and reduce the rent. Now, unfortunately, if you do that, it very well may stick. In other words, that may be a permanent rent reduction. There just might not be a way around that. I've worked with some landlords, and there are some circumstances where we've been able to create some temporary rent reduction. So let's say you give them a 6-month rent reduction, for a couple $100 or whatever, and then the rent returns back to what it was, pre-reduction. But even in those situations, there's always a caution that you may get stuck with that, reduced rent. So, definitely consult with an attorney before agreeing to that. Always put it in writing and make sure it's very clear as to what the understanding of the terms and the agreement are. And yeah, I've had a lot of landlords step up and do that. And especially like in San Francisco, there's, at least from what I'm hearing from, property management companies and some of the bigger property owners, is that there are a lot of vacancies right now, and they're having a tough time filling vacant units. So they are more than happy to keep the tenants they have, even if it means reducing the rent, and even if it means that may be a permanent reduction. So yeah, I have a lot of landlords working with tenants by doing that.
Mm. Okay, Brad, I want to ask you, have you seen any questions that you've seen in the Q&A that you'd like to address?
Yes, yes. Thank you. Thank you. I just want to go ahead and take a couple of clarifying questions. I think it's
Yeah.
really important. And Brian Stone's been very active on the,
I saw.
so he has a couple of really good ones I want to address because he kind of reiterated what I saw earlier. And having to do with the parent child, does it apply to a living trust? And the answer is yes. So if your property is held inside a living trust, your typical family revocable living trust, that is a mechanism for parent child. So I make sure I want to clarify. LLC does not qualify. LLC child does not qualify, but a living trust, the child does qualify, because typically it's the parents who set the trust up, and the kids are typically the beneficiaries of such trust. So that does apply. Another thing just for clarifying, and he talked about the living trust also applies for step up in basis. So if the property is held inside a trust, and then you have that same mechanism where it transfers from parent to child, yes, it does get a step up in basis. It doesn't have to be an individual to an individual. The trust can be the giving entity. And then one last thing, which I thought was a pretty sophisticated question that Brian asked, was whether if the property is held or splitly held between an exemption trust and a survivor's trust, does the step up in basis apply? It would only apply, Brian, to the survivor's portion. The step up in basis does not apply to an exemption trust. It's one of the things that you lose because that is not subject to taxation. So since the government never got its pound of flesh out of you by putting the property into the exemption trust, they're not then going to give you a step up in basis on top of that as well. So that would be subject to full recapture of capital gain upon the beneficiary sale of those exempt trust assets. So
Okay.
Very sophisticated question. I want to make sure I got that one to him.
Great. Yeah, that was a good one. And what I want to really end this with, because the questions are still coming in, and I'll be sure to send these questions to you, Brad, and to Steve, so you guys can answer them at your convenience. And also, I just want to end this with asking you both what your opinion is now with investing in California and living in California. Brad, I know you work with people outside of California as well.
Yep.
And, Steve, you're in one of the most tenant-friendly cities in the country. And, is this a good time to exit? Should we stay here and, hold out while, and just adjust to these new laws that are coming on? So, Brad, I'd love to hear your opinion, and Steve as well.
Well, I can just speak mostly from my clients that are property owners and business owners. I got to tell you, Alexandria, that probably the last easy 2 years to 18 months, I've done just as much, we'll call it like mass exodus planning, as I have done asset protection planning. Seems to be like Idaho, Nevada, Florida, Texas. These all seem to be really popular places. And what are the things that clients need to do if they get a residency audit from the FTB when they're trying to basically divest themselves from California? And I think one of the big things that's a surprise to them is that there's a thing called California sourced income versus non-California sourced income. So how you set up an exit is very important, especially if it's how you decide to sell property. If you're selling the dirt, no matter where you live, doesn't make a difference. It'll be subject to the California capital gain tax. But there are other tools that we use that can help you to mitigate or completely avoid the California tax. And that's being done primarily through the use of other state trusts. And that's not just limited to property, it's also listed to businesses. So I think California is a great place. I just think that the taxing policies here are a bit draconian, I think is an appropriate adjective to use. And I do, just as, like I said, just as much planning for clients inside as I do for clients who are exiting. And when I do have opportunities to speak outside of California, I can tell you that the rest of the country looks at us like we're a little off. So take that as you will.
All right. And then for those of you who need help with estate planning or asset protection, Brad's information is on the screen. If you just text yes, BC 2474747, you can set something up with Brad to get an actual consult in case you are trying to exit or trying to adjust to what's happening here. Steve, closing comments.
Sure. So, yeah. So in general, real estate has been a great investment, particularly in the Bay Area where I practice, but really throughout California. So even in down times, of course, you have the fluctuations, but real property has generally held pretty strong in the Bay Area, and I'm assuming throughout other areas of California as well. And even with all these tenant-friendly laws and protections, like San Francisco, for instance, where I practice, that seems to not have had a significant impact on the values of properties adversely. In fact, it may have the opposite effect. Because what's going to happen when a tenant moves out and you can get market rates? Well, you're going to jack that rent up as high as you possibly can because maybe you couldn't give increases for a number of years. And that's what all the landlords are doing. So property values seem to be, pretty strong and steady, even in downtimes in the Bay Area. And I don't know, I can't speak to all throughout California and other areas, but in general, it's been a pretty good investment. And with us defeating, proposed laws like Proposition 21, which would have opened the door for rent control of vacant units. Now that may have had a different effect because
15, I'm sorry.
that would allow local jurisdictions to control even vacant units. So if you had a below market rent and that tenant moves out, you're generally allowed to raise the rent to whatever you want, not if Proposition 21 had passed and the local jurisdictions could have controlled that. So more like a New York type of rent control. And in terms of laws, I don't really see anything coming out, more favorably for landlords anytime soon. You're just going to see more and more laws and probably refinement of the tenant rent and eviction control, AB 1482, of making that more restrictive and more tenant friendly as well on a statewide level. And locally, same thing. More rent and eviction control jurisdictions keep popping up all over the place. So if you're inclined to invest, you're just going to have to weather all these tenant-friendly laws. But overall, the property values have held pretty strong, and there have been pretty good investments.
Yeah, that is true. Well, I really do appreciate both of you coming onto the call here. Your insights, everything is just so helpful for us because I know landlords are trying to be attorneys themselves sometimes and, getting themselves into trouble because they don't really know, what all these changes that are happening so quickly. And you both deal with this in the day-to-day. And so it's so valuable to have that insight. So again, everyone, recording is going to be sent to you tomorrow with Brad and Steve's info. Steve will hopefully share the slides with me today so I can share them with you tomorrow. And I hope to catch you all soon. And maybe next time we'll have another update, to see what else is going to happen in this next year. It seems like every 5 to 6 months, something's changing. So we'll be in touch soon with some other new topic for you guys. And I appreciate everyone who's made it on the call for this long. And thank you, Brad and Steve. I appreciate it.
You're very welcome. Thank you.
Thank you, Alexandra.
Bye-bye.
Take care.